my client runs an Applebee's restaurant. The plaintiff came to the restaurant and claims that she tripped on a flipped up floor mat in the entryway as she was leaving after eating. And as I said, I think we have multiple independent reasons why we're entitled to summary judgment. The first of those would be that there's no evidence that's been presented of an unreasonably dangerous condition. The mere fact of a fall alone does not establish that. Uh, there's no liability also for a condition from which no unreasonable risk is to be anticipated. And instead, the plaintiff has to present evidence that the defendant should have realized the condition involved an unreasonable risk of harm. And here, the plaintiff has not and cannot make any such showing. There have been no other incidents of any kind involving either the entryway or a floor mat. That's undisputed based on the declaration we submitted from Freddie Mendoza, who's the manager there at the restaurant. Also, in her deposition testimony, plaintiff herself admitted that she has no evidence to the contrary. Again, from the declaration of our manager, tens of thousands of people have gone through this entryway across a mat without any sort of incident whatsoever. In a single incident being plaintiffs after tens of thousands of non-incidents does not establish a unreasonably dangerous condition as a matter of law. So for that reason alone, we prevail and summary judgment should be granted. Second, even if you assume for the sake of argument that there was an unreasonably dangerous condition here, defendant still had no notice of that fact. Plaintiff admits in her deposition testimony that there's no evidence of actual notice. It's undisputed that the defendant did not know of any issues with the floor mat before the incident took place. And again, this is the only incident of this type that has ever occurred. So actual notice cannot be established. Similarly, no constructive notice can be established. Under the case law, it's very clear that the plaintiff has to establish how long the unreasonably dangerous condition existed, essentially to show that the defendant had sufficient time to discover it and should have discovered it. But here, the plaintiff admits that as of 8 seconds prior to her incident, there were no issues with the mat. And we know that from the video that we have. So there were no issues. And on top of that, the undisputed evidence is that my client conducted at least 4 or more inspections every hour, a critical path inspection, which would take them to the entryway area. And there were no issues of any kind that were found with either the mat or the entryway generally. So for that reason, constructive notice can't be established either. And so even if you assume there was an unreasonably dangerous condition, which there was not, we had no notice of that. And so for that second reason, we also are entitled to summary judgment. Third, there is a Pimentel exception to the notice rules that exists, but in order for that exception to apply, the risk in question has to have been, quote, continuous or foreseeably inherent. And the case law, including very recent case law, dictates that historical evidence of other incidents is required. And you'll see this in the reply briefing that we submitted in response to the plaintiff's response. But there's a case called Level, and that case said, quote, that the facts there were, quote, devoid of any historical evidence of other incidents. And because of that, the Pimentel exception did not apply. Similarly, there's a case called Brower, and that case found that 3 similar incidents over the course of 3 years still did not establish, quote, the continuous or inherent risk required by Pimentel. So here, as I've said several times now, there's no evidence of any other similar incidents at all ever occurring. And we know that from the Mendoza declaration, which is undisputed. So despite tens of thousands of people going through this entryway, there've been no issues. And there's no historical evidence which is required of such issues. And so because of that, the Pimentel exception to the notice rules doesn't apply. Fourth, even if you assume for the sake of argument that the Pimentel exception actually does apply here, there's no evidence that my client breached any duties that flow from that exception. The exception is very clear. It does not establish strict liability. It also does not shift the burden of proof to the defendant. The plaintiff retains the burden of proof, and the plaintiff still has to prove that the defendant failed to take reasonable care to prevent the injury. Here, as you'll see, plaintiff has presented zero evidence on that point, none whatsoever. The plaintiff has to show, under the case law, that the number of inspections that was conducted was not adequate due to the known frequency of risk, and that the known frequency of risk required greater diligence and vigilance, excuse me. And again here, no other similar incidents ever occurred, despite near constant use of this entryway. And on top of that, it's undisputed that the defendant conducted 4+ inspections per hour. So just like the Coleman case that we cited at length in our opening motion, that case says the adequacy of housekeeping is not a jury question unless there's some basis for concluding that what the defendant did was insufficient. In Coleman, there were actually 2 to 3 prior incidents of the mat, in that case, coming loose, and the defendant there only inspected once per day, and still that was not enough for the Pimentel exception to apply. Well, here, again, no similar incidents of any kind ever, and we were conducting inspections 4 times per hour. So comparing our case to Coleman, the Pimentel exception cannot apply. Each of those reasons standing alone entitles the defendant to summary judgment. And ultimately, while there was a lot of briefing, because we wanted to lay it out very clear in a factual sense, it's really straightforward that we are in fact entitled to summary judgment. When you have a chance to review the plaintiff's response, you will see that there's a 1-sentence request therein for a 56F continuance. That continuance should not be granted. This case has been around and pending for over 3 years now, 3 years and 1 month. The plaintiff has never issued written discovery to the current defendant. The plaintiff has never conducted any depositions of any kind. The summary judgment motion was originally filed in April. As we mentioned earlier, we did agree to continue the hearing date voluntarily at one point at plaintiff's counsel's request. And nonetheless, there's never been any effort of any kind to take any additional discovery or any discovery at all during that interim period while the motion was pending. On top of that, 56F requires an affidavit from counsel explaining why the continuance needs to be granted. Case law establishes that you have to set forth a good reason for why there was delay in pursuing discovery previously. You have to show what the facts you are seeking would show and why they would actually create a question of fact. And the 56F continuance motion is exactly 1 sentence long. So that standard is absolutely not satisfied. If you have any questions, I'd be more than happy to address them, but that's the substance of our argument.
Thank you. All right, Mr. Kylo, go ahead.
Yes, thank you. So I think on the unreasonable dangerous condition point, I think it's clear that a doormat that shifts around and is not affixed to the floor, that gets caught on a door when the door opens and flips up and causes a below the knee amputee to catch a prosthetic leg running and trip. I think that's an unreasonably dangerous condition. They could have easily affixed the mat to the floor in some way so it didn't slide up against the door, whatever happened, and flip over and cause a tripping hazard. This mat was clearly installed by the defendant, so that under the Pimentel exception that he was arguing, I've got my briefing right here. It states that the unsafe condition must have either been caused by the proprietor or his employees, or the proprietor must have actual or constructive notice of the dangerous condition. It's clear that this is all within the custody and control of the defendant here, and they installed the mat themselves. I don't know how they can claim to not have notice of this mat when they installed it themselves, and it sits directly across from the host stand where the employees stand every single day. The notice requirement goes to the foreseeability elements of the negligence claim, and I think it's clearly foreseeable that, I mean, they could have tested this out to see what would happen when they moved around the mat, because it obviously slides around, and it's not fixed to the floor. And seeing that it could perhaps catch on the door as patrons exit. I mean, so he mentions that tens of thousands of patrons have gone into the store, but the defendant has to buy take the plaintiff as she is. And as I stated, I don't think it's mentioned in his motion, but it's mentioned in my briefing. My client is a below the knee amputee on her leg, so she wears a prosthetic leg, which is what actually caused the mat. The front door is the primary ingress and egress route for every single customer that patrons this Applebee's. So that satisfies the exception in Pimentel that I think the quote is such notice. So the notice element need not be shown, however, when the nature of the proprietor's business and its methods of operation are such that the existence of unsafe conditions on the premises is reasonably foreseeable. I think having this in the ingress egress route, the primary ingress egress route for the Applebee's, is clearly foreseeable. That's their business model. That's how their patrons come in. That's how every single customer comes in. So not only was the dangerous condition caused by the proprietor or his employees, but also the nature of the business model makes it entirely foreseeable that a floor mat unaffixed to the floor itself may shift around and cause a tripping hazard. That's the standard under Pimentel. So I'm sure hundreds of employees and patrons walk through that every single day. So again, primary ingress and egress route. Those employees could have easily, I mean, I don't know how they don't have notice for something that they walk over every single day and are staring at every single day. So the fact that no one has previously tripped and fallen is not important here, where the hazard itself is entirely foreseeable. Again, the final note is that the defendant has to take the plaintiff. I mean, you can consider an eggshell or a particularly susceptible, plaintiff here, in that she's an amputee. Those tens of thousands of people who have, traversed in and out of this restaurant aren't necessarily amputees. So she was particularly susceptible to this injury. On the CR56F issue, the only discovery that I think I would need would be, maybe get an expert to go out there and, measure the mat and see how it moves, maybe some friction analysis between the mat and the floor for how it shifts around, how thick it is, and how low to the floor the bottom of the door is, so if it can catch easily that way, and or interviewing or taking the deposition of the employee or the manager that wrote the declaration to cross-examine him on this declaration. And unless you have any questions, that's all I've got.
Okay, thank you. Any rebuttal, Mr. Johnson?
Yeah, I mean, the Pimentel exception, Your Honor, clearly requires historical evidence of other similar falls. And you'll see in our reply, we discussed those cases at length. One, I'll quote, 3 similar incidents in the past 3 years does not establish the continuous or inherent risk required by Pimentel. You have to have historical evidence of other such incidents. We didn't have that here. It's never happened before. So the Pimentel exception does not apply. For the same reason or very similar reason, there is no unreasonably dangerous condition. Just because an incident happened once does not mean that it should have been anticipated by the defendant. Tens of thousands of occurrences where there are no such problems, and then a single occurrence where there is, that does not show that there was an unreasonably dangerous condition that the defendant should have anticipated. And finally, there's clearly no notice here. If you look at the deposition testimony from the plaintiff, she admits that. There's no reason that defendant should have anticipated that there was anything wrong with the mat. That's established by the Mendoza Declaration. It's established by the plaintiff's own deposition testimony. And I believe under the case law, it's very clear that we're entitled to summary judgment.
Okay, well, thank you both. That is helpful for sake of completeness of the record, although I think the primary facts and arguments have been made in the pleadings. I'm going to verify for both of you when I have a chance to review the reply and the SIR reply, and then I'll get you a written decision fairly quickly.
Thank you, Your Honor.
Thank you.
Thank you
Appreciate
both.
it.
Yeah.